Supreme Court AR-15 and magazine cases. What if the most popular rifle in America, the AR-15, and its magazines were ruled to have no Second Amendment protection? This isn't just an idea. The Supreme Court is now looking at this question. The basic question they need to answer is, does the Second Amendment protect the right to own AR-15s and their magazines? Let's talk about the news we got today about these cases and what it means moving forward. Before we continue, if you want to support the channel, the easiest way is to subscribe. Also, make sure YouTube hasn't unsubscribed you by mistake. I also want to thank First Form, one of our main supporters. First Form is an excellent company. Their values are amazing. They support freedom, America, and the Second Amendment. If you want to get healthier and need good supplements, check them out using the link below. Right now, if you use that link to order a supplement, you'll get a free 5-pack of protein sticks from First Form. I highly recommend them. They're excellent. Check them out using the link below. As I said at the start, in this video we'll discuss an important rifle and magazine ban case that the Supreme Court looked at last Friday. We now have some new information about these cases. The main case I want to discuss is Vermont versus Cook County. In this case, the people challenging the law are regular citizens and groups like the Second Amendment Foundation. They're fighting against Cook County's law, which makes it illegal to sell, transfer, or even own so-called assault weapons. This case tries to use recent comments made by Justice Kavanaugh after the Supreme Court turned down the Snope rifle ban case last term. When they denied that case, Justice Kavanaugh said that very soon the Supreme Court would need to look at this rifle ban issue. He clearly stated that this would probably happen within 1 or 2 court terms. The people filing this lawsuit want their case to be the one that makes the Supreme Court keep that promise. Last Friday, the Supreme Court held a private meeting to think about both the rifle ban issue and the California magazine ban issue, which is in the case Duncan versus Bonta. Today we got news about both of these cases dealing with rifle bans and magazine bans. Both have been put back on the list for another meeting on December 12th. Very soon, these cases will be discussed again. This could mean several things for the future of these legal challenges. Let's talk about what's happening in these cases. Here's how this rifle ban case got to the Supreme Court. Back in 2021, the rifle ban lawsuit was filed in a federal court in Chicago. The people filing the lawsuit challenged the county's ban using the Second Amendment as their argument. In 2024, while the case was still being decided in the lower court, Illinois passed a statewide assault weapon ban. It's called the Protection of Illinois Communities Act, which people call PICA. We've talked about that case on this channel before. In many ways, it's similar to what Cook County already did with their law. Around the same time, the Seventh Circuit Court decided a case called Bevis versus Naperville. They upheld Illinois' law and said that AR-15s were too military-like to be protected weapons. They ruled that guns that are useful in military service could be completely banned and restricted. The district court had to follow what the Seventh Circuit already said in that Bevis case. So they ruled in favor of Cook County's rifle ban. The district court gave a quick judgment supporting Cook County. In 2025, right after the Supreme Court refused to review the Snope case, the Seventh Circuit Court confirmed that lower court decision. They relied heavily on the Bevis case, treating AR-15s as basically civilian versions of M16s. Because of this, they said AR-15s are not protected by the Second Amendment. Now, the people filing the lawsuit are asking the United States Supreme Court to get involved and solve this problem. They want the Supreme Court to decide once and for all whether Americans have the right under the Constitution to own AR-15s and similar semi-automatic rifles that states are banning completely. Cook County recently responded by saying the court should once again refuse to review the rifle ban case and ignore this issue. Cook County argues that this case doesn't need the court's attention for several reasons. First, they say there's no disagreement between different circuit courts on whether rifles are protected weapons. Second, they claim this case is a poor choice for Supreme Court review because the plaintiffs, in the county's view, didn't follow some basic court rules. They claim the plaintiffs skipped the evidence-gathering phase and offered no proper evidence to support their claims. Basically, the county is saying that the plaintiffs were in such a hurry to get to the Supreme Court that they missed some basic steps needed to have the kind of evidence the Supreme Court needs to review this case. Finally, Cook County says the lower courts were correct on the legal merits of this issue. In summary, they're saying this case has procedural problems, the law is already settled, and it's not the right case for Supreme Court review of this important issue. At its heart, this case asks the Supreme Court to finally do what we've all been asking them to do for many years: take up a state rifle ban case and also, in the Duncan case, take up the magazine ban question and strike those bans down. Both of these cases went to a Supreme Court conference last Friday. The Vermont rifle ban case and the California Duncan case about magazine bans both went to this meeting. You might remember that the Duncan case from California was already granted review, sent back, and returned to lower courts by the Supreme Court in earlier terms based on what happened in the Bruin decision. But like other Second Amendment cases, the lower courts and the Ninth Circuit didn't properly apply Bruin. This has caused the Duncan magazine ban case to end up back at the Supreme Court again. Today we got news that after that conference, both the Vermont and Duncan cases have been put back on the list for another conference date on December 12th. You might wonder why the Supreme Court putting a case back on the list is important for what could happen in these challenges. It's because all Supreme Court data and tracking from past cases shows that a case has better odds of being granted review by the Supreme Court if it's put back on the list at least one time, but usually only once. One relist isn't bad for a case. Actually, in many ways, it's the best possible situation for these types of challenges. In fact, according to Supreme Court data from the court's 2016 to 2020 terms, between 31% and 43% of cases that were relisted only one time were eventually granted review. And between 66% and 75% of all cases that were granted review were relisted at least once. So the basic truth is that a case relisted just once has a much better chance of being granted Supreme Court review. But I also want to point out that all the data shows that multiple relists of a case, like what happened recently with the Snope rifle ban challenge from Maryland, is actually a bad sign. Usually that means the case is going to be denied review. The data shows that a case becomes less likely to be granted review if it's relisted twice, 3 times, 4 times. Basically, the more times a case is relisted, the lower the odds go for the court to grant review to the challenge. Multiple relists often means the case will be denied review and that one or more of the justices is possibly writing some kind of dissent or statement about that case. So the cases being relisted once is not a bad thing. However, if we start to see these cases get multiple relists, like 3 or more times, that's a strong sign they will be denied. At best, maybe one of the justices will write a statement in the case, perhaps something like a dissent. Up to this point, the Supreme Court has avoided rifle and magazine ban cases like they're dangerous. However, we'll know very soon whether Kavanaugh's statement and promise that they would take this type of issue within a term or two was actually true, or if it was just another empty promise. So that's what's currently happening with these important rifle and magazine ban cases that went a conference last Friday. They've now been relisted. All hope is not lost yet. One relist is not a big problem. Sometimes it can actually be a good sign. However, we'll be watching the Supreme Court closely going forward for their order list. We'll be watching them after the next upcoming conference because if we start to see these cases get multiple relists, that's a bad sign for these challenges moving forward. So that's what's currently happening. As we get more information and as things develop more, I'll let you know. If you like this video and you want to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the 2 videos on the screen that the YouTube algorithm thinks you'll find helpful. But as always, thank you so much for all of your support. And remember, this nation was built by armed scholars, and this nation will be kept strong by armed scholars.